So it is unlawful or a violation of California state law to post online or sell personal information of elected or appointed officials in the state. This is found in California's Government Code Title 1, Division 10, Part 5, Chapter 14, Article 3. The first is Section 7928.200. Now, this section says that an interactive computer service or access software provider cannot be held liable unless the service or provider intends to abet or cause imminent great bodily harm that is likely to occur or threatens to cause imminent great bodily harm to an elected or appointed official. Section 7928.205 prohibits any state or local agency from posting the home address or telephone number of any elected or appointed official on the internet without first obtaining the written permission of that individual. Section 7928.210 prohibits any person from knowingly posting the home address or telephone number of any elected or appointed official or of the official's residing spouse or child on the internet, knowing that person is an elected or appointed official and intending to cause imminent great bodily harm that is likely to occur or threatening to cause imminent great bodily harm to the individual. A violation of this section is a misdemeanor, and a violation of this section that leads to the bodily injury of an official or the official's spouse or child is a misdemeanor or a felony. Section 7928.215 defines the terms publicly post and publicly display, basically to mean when somebody intentionally communicates or otherwise makes available to the general public. Now, persons, businesses, and associations are prohibited from publicly posting or publicly displaying on the internet the home address or telephone number of any elected or appointed official if that official has, either directly or through an agent, made a written demand of that person, business, or association to not disclose their home address or telephone number. Additionally, a written demand made under this section by a state constitutional officer, a mayor, a member of the legislature, of a city council, or a board of supervisors is required to include a statement describing a threat or fear for the safety of that official or for any person residing at the official's home address. The written demand made under this section by an elected official is effective for 4 years, regardless of whether the official's term has expired before the end of that 4 year period. And a person, business, or association that receives the written demand of an elected or appointed official must remove the official's home address or telephone number from public display on the internet within 48 hours of delivery of that written demand. Moreover, after receiving the elected or appointed official's written demand, that person, business, or association is thereafter prohibited from transferring the appointed or elected official's home address or telephone number to any other entity through any other medium. Section 7928.220 authorizes an elected or appointed official to designate in writing the official's employer, a related governmental entity, or any voluntary professional association of similar officials to act on behalf of that official as their agent with regard to making a written demand under this article. Additionally, an appointed official who's a district attorney, a deputy district attorney, or a peace officer may also designate the official's recognized collective bargaining representative to make a similar written demand on behalf of the officials, on behalf of that official. Section 7928.225 provides that if an official's home address or telephone number is made public as a result of a violation of this law, then that official may bring a civil action seeking injunctive or declaratory relief in any court of the state. Additionally, if a court finds that a violation has in fact occurred, it may grant injunctive or declaratory relief, and it's required to award the official court costs and reasonable attorney's fees. Additionally, a fine not exceeding $1,000 may be imposed for a violation of a court order for the injunction or declaratory relief that's been obtained. Section 7928.230 prohibits any person, business, or association from soliciting, selling, or trading on the internet the home address or telephone number of an elected or appointed official with the intent to cause imminent great bodily harm to the official or any other person residing at their home address. Moreover, an official whose home address or telephone number is solicited, sold, or traded may bring a civil action in any court. And if the jury or court finds that a violation has actually occurred, then it is required to award damages to that official in an amount equal to 3 times the actual damages, but no less than $4,000. There's also Article 4 of Chapter 14. This deals with personal information of agency employees. So Government Code Section 7928.300 provides that the home address, home telephone number, personal cell phone, and birth dates of all employees of a public agency are not public records, and therefore they are not open to public inspection. Now, there are 4 specified exceptions provided in Section 7928.300. Moreover, a personal email address of all employees of a public agency is not deemed to be a public record and is not open to public inspection. There are a few specified exceptions. However, this does not limit the public's right to access the content of an employee's personal email that's used to conduct official public business. And finally, upon the written request of any employee, a public agency is prohibited from disclosing the employee's home address, telephone number, personal cell number, personal email address, or birth date. And the agency is prohibited from removing that personal information that is obtained from any mailing list that is maintained by the agency, except if the list is used exclusively by the agency to contact the employee.